He works with the Americans United for Separation of Church and State, and he's got quite an awesome biography. I don't know if anybody read it online, but he is the Senior Litigation Counsel currently, and he's got a lot of awards behind him, has a Harvard Law degree, and some oratory awards that are pretty impressive. I wish he could come in and speak to my debate kids at school. He's worked on a lot of cases that have been in the news. Currently, he's working on Notre Dame versus Burwell, which is access to contraception case, a young lady at Notre Dame University. Also worked on the Hobby Lobby case that we all followed closely. He's also working on a case in New Jersey that involves discrimination against atheists, not allowing us free speech, and same-sex marriage issues and religion in school. Sounds like he's quite busy and doesn't have much time to do much to enjoy living in D.C. and all the exciting stuff there. So if you want to talk more with Greg, stay for lunch. And if you want to, if you're on Twitter, make sure that you follow him. His what do they call it? Your handle? I don't know. I'm not on Twitter. I don't tweet. His handle is the Lipper. So, without any further ado, please welcome Greg Lipper.
Okay. Great. Thank you. Can everyone hear me? Yes. Great. All right. So, the job of a church-state litigator has changed, I would say, significantly over the last couple of years. The traditional types of church-state cases have often revolved around things like religious displays, giant statues of Ten Commandments monuments at courthouses, or school-sponsored prayer at graduation ceremonies, or taxpayer funding of religious organizations, to name a few. And don't get me wrong, those are still big issues. We're still litigating those cases. If anything, there are more of them. But at the same time, over the last couple of years, we've seen, I'd say, a new generation of cases involving church-state separation around the issue of religious refusals. And Hobby Lobby being, I think, the most prominent example of instances in which, and oftentimes members of minority religions, bringing free exercise claims in a manner that are essentially seeking to impose their religious beliefs on others, often at the expense of laws protecting women, or LGBT people, or other vulnerable populations from discrimination or guaranteeing equality. Religious refusals, religious accommodations have been a part of religious freedom and have been a part of church-state separation for a long time, but the way they're being used now, the way they've been used over the last few years, and the way they're going to be attempted to be used, I think, in the near and perhaps long-term future, is unprecedented. And it's creating new challenges for church-state separation, and is, I think, posing significant challenges for the right for all people to live consistent with their beliefs and not be forced to submit to the beliefs of others. So what I'm first going to do is talk about the history of religious accommodations and religious refusals, and how essentially we had a fairly broad consensus as to how religious exercise should be accommodated and how it shouldn't be. Then I'm going to talk about the contraception coverage litigation and Hobby Lobby in particular, and how Hobby Lobby has really turned everything topsy-turvy and how we understand these things. And then finally, I'm going to look at the future of religious refusals litigation, not only with things like contraception and healthcare, but also and especially the intersection of marriage equality and free exercise claims, as we're starting to see more and more of. So obviously the First Amendment protects both the free exercise of religion and it prevents the establishment of religion. And there's always been some tension in those things, and one of the places the tension arises is what happens when you have just a neutral general law? So I think everyone agrees that if the government singles out a particular religious group, if the government says, Muslims may not worship on Sundays, or Christians may not use wine at their ceremonies. Or, atheists must register in advance with the government in order to meet. I think everyone agrees that that type of law would violate the Free Exercise Clause, if not the Establishment Clause as well, because it's singling out a religious group, it's discriminating on the basis of religion. And so that's the type of thing that presents a pretty clear violation of the Free Exercise Clause. But the harder case, and perhaps the most common source of disputes, is what happens when the law is general. It's not aimed at religion, but it happens to have the incidental effect of interfering with someone's religious exercise. So, you might imagine a law that, say 100 years ago, that simply prohibited the use of wine. And there are obviously many religious traditions for whom wine is a part of their religious ceremonies. And so that would be an instance in which the law isn't targeting religion, the law isn't singling out religion, it applies equally to everyone, it was motivated by other things, but it could end up having a significant effect on people's religious exercise. And you can imagine all sorts of things. You can imagine in the prison context, if the standard lunch is a ham sandwich, that might interfere with the dietary restrictions of certain religious groups. And you can, and on and on and on. And so these have come up at various points in history, and although there have certainly been hard cases along the way, I would say there have been some general principles, which is, first of all, as a general matter, there has, I think, been some effort made to accommodate free exercise when it's reasonable to do so, and when doing so doesn't impose directly on others. So, for example, cases of conscientious objectors to wars. If people had religious objections to war, they were able to receive an exemption from being drafted. And in fact, that was actually even extended to those with certain non-religious moral objections as well. Things, for instance, people who lost their jobs because they were unwilling to manufacture munitions for a war effort were still in some cases able to receive unemployment benefits. And so there's a lot of, I think, examples like that, or even something as simple as my child has school today, but today is an important religious holiday. Can the child stay home? So these are sort of things that I think as a general matter make sense. There, I think, are some who would say that even that it violates the separation of church and state because it's kind of singling out someone who's religious for special treatment. But as a general matter, I think those things are helpful for religious diversity and helpful for civil liberties. And I think the important thing underlying those is that members of the religious majority are often accommodated sort of almost automatically. No one has to go to school on Christmas, but someone who's a religious minority may have school on a holiday that's equally important to them. And so the notion of religious accommodations, even from generally applicable laws, should be available and were available under the Free Exercise Clause within reason. Now, the right to an accommodation was not unlimited, and courts did make special effort to make sure that the right to an accommodation didn't come at the expense of third parties. And so there were some requests for religious accommodations that were rejected. So to give you a couple of examples, there was a business owner, an Amish business owner, who objected on religious grounds to withholding Social Security payments and making the Social Security tax payments for his employees. The Supreme Court rejected that claim unanimously, in fact, because to accept the claim there would have imposed a burden on the employees of that company who would have lost the protection of the Social Security system. There was a similar challenge by a group that didn't want to comply with minimum wage and overtime pay requirements. And again, even if there was a sincere religious belief that doing so offended religious belief, that again would have come at the expense of employees who were entitled by law to certain minimum wages, and so the court rejected that claim. Perhaps most significantly and controversially, in the early 1980s, Bob Jones University had lost its tax-exempt status because it banned interracial dating. And although that was an 8-1 decision, most of the court anyway, was pretty swift in rejecting that free exercise claim, given the government's compelling interest in eradicating discrimination on the basis of race. And so you have these cases in the 60s, 70s, and 80s, even as the Supreme Court got more conservative, as it had had been. By the early 80s, I think the court was, the Warren court was largely a distant memory, but the court was pretty united in when accommodations were available and when they weren't. And they weren't available when they would have sought to impose one person's faith on someone else. So that was, I think, a relatively, not controversy-free, but a relatively stable consensus. Things changed in 1990, at first in one direction and then in another. So in 1990, the Supreme Court heard a case called Employment Division versus Smith. And Mr. Smith was a Native American, and as part of his religious exercise, his religious ceremonies involved ingesting peyote. Peyote is illegal under federal and many states' drug laws, and Mr. Smith had a job with a government agency in Oregon, and he was fired because he was engaging in illegal drug use. So he brought a challenge under the Free Exercise Clause of the First Amendment. He won in the lower courts, but then it went up to the Supreme Court. And the Supreme Court in this 1990 decision rejected his free exercise claim, and in so doing, changed the landscape of the Free Exercise Clause. What the Supreme Court said, and it was interesting because it was a decision by Justice Scalia, which did surprise a lot of people. The Supreme Court said if the law is neutral and generally applicable, in other words, if it targets everyone and doesn't single out religion specifically, then the Free Exercise Clause does not give you a right to an exemption. And so in Mr. Smith's case, it doesn't matter that the reason he was violating the drug laws was because of a religious obligation. The law was neutral, the law didn't single out religion, no free exercise claim, end of story. And so that was a sharply divided opinion because there were many on the court who believed that in some cases the Free Exercise Clause should require exemptions as it had in the past. But that was the new rule going forward, and that stands today still under the First Amendment. So under the Constitution, as of this 1990 decision, as long as the law is neutral on its face, and as long as the law isn't singling out or motivated by animus towards a particular religion, no exemption allowed. So to give you some examples, if there is a government regulation that says everybody on the police force has to be clean shaven, if your religious beliefs require you to wear a beard, doesn't matter, no free exercise right to an exemption. If the standard diet in your prison is mixing meat with eating cheeseburgers and you are kosher, doesn't matter, no free exercise right to an exemption, and on and on. There was a lot of backlash against this Supreme Court decision. In fact, this was one of those rare cases in which people on the left and people on the right and a lot of people in between all objected to the Supreme Court's decision. And because although I think a lot of people recognize that certainly you're not always entitled to an exemption, certainly you're not entitled to be a law unto yourself, there are significant cases, like the examples I just gave, in which especially religious minorities are vulnerable to the will of the majority. As I said before, the political process will often take care of those in the majority. But if you're a Muslim or a Sikh or a Jew or a Buddhist or a Native American practitioner or et cetera, et cetera, et cetera, the political branches may be either ignorant of or simply not concerned with accommodating your religious beliefs. And so there was a lot of concern, including concern from progressive groups and progressive religious liberty groups, that this absolute rule from the Supreme Court was actually going to undermine the cause of religious liberty and undermine the separation of church and state. So in 1993, in sort of a giant kumbaya moment in the history of American religious freedom, pretty much everyone came together and Congress passed and the president signed the Religious Freedom Restoration Act, which passed unanimously or near unanimously in both houses of Congress. In the Senate, it was sponsored by Ted Kennedy and Orrin Hatch, which are two people that did not co-sponsor legislation very often. And what the Religious Freedom Restoration Act said was we are essentially bringing back the pre-1990 standard. So even if the law does, even if the law is neutral and is generally applicable, if it does have the effect of creating a substantial burden on religious exercise, the government can apply the law only if the law is the least restrictive means of advancing a compelling governmental interest. And the intent of the law was to restore the pre-1990 standard, which meant sometimes you might get a religious accommodation, but sometimes you wouldn't. It would depend on the strength of the government's interests and the interests of other people as well. And so that was what was created. Bill Clinton signed it, talking about the proverbial miracle from above that could bring all of these folks together. And everyone was happy for a while. Originally, the law was intended to apply both to the federal government and to states. In 1997, the US Supreme Court said that the law could not apply to states because of federalism concerns, but many states have enacted similar measures, kind of trying to bring back the pre-1990 understanding of the Free Exercise Clause. So everyone was, for a little while anyway, very happy. But what happened? Well, what happened was that as we got later into the 90s and as we kind of moved into the next century and millennium, we started to see more aggressive requests for religious accommodations and essentially requests in a lot of ways to relitigate the culture wars using these types of claims. Actually, in the late 1990s, there were a few cases. They ended up getting dismissed, but there were a couple of cases involving landlords who had religious objections to renting apartments to unmarried couples. And in many states, there are laws prohibiting discrimination on the basis of marital status. So that was maybe the first red flag that there were going to be issues with a statute like the Religious Freedom Restoration Act. So those things came up, but generally it didn't get too far in court. But things really changed with the Obama administration and with the Affordable Care Act. As I'm sure everyone knows, but I'll go over it briefly just to refresh everyone's recollection. So as part of the Affordable Care Act, all insurance plans must include coverage for a range of preventative care. And that preventative care includes preventative care important to women, and that includes 20 different FDA-approved contraceptives. And the reason this requirement was added was because there was a lot of evidence showing that women's health was often ignored or not taken as seriously, and that women were paying far more for their health care than men were. And so the Women's Health Amendment to the Affordable Care Act and the implementing regulations by the Department of Health and Human Services said, when you provide an insurance policy, you have to cover a basic basket of goods, and that basket of goods needs to include contraception. This raised some hackles because there are some employers said that they had religious objections to providing even insurance coverage that included contraception. There was an exemption in the contraception coverage regulations for houses of worship. There ended up being an accommodation for religious nonprofit organizations, which I'll talk about a bit later on. But all of a sudden, you had many for-profit corporations whose owners claimed that they objected on religious grounds to including contraception coverage in their insurance policies. There were mining companies and organic food companies and cabinet makers and most notoriously Hobby Lobby, which is a large chain of retail craft stores. Now, as a bit of a footnote to this, it turns out that many of the people that ended up bringing lawsuits in court had actually been covering the very drugs and devices they claimed to object to, and they all told a similar story that after in 2012, when the regulation started, we consulted our insurance policies and we were shocked to discover that we actually had been covering contraception, and so now we want to stop. But in any event, these claims were starting to work their way in court, and these companies all brought claims under the Religious Freedom Restoration Act, that law that was passed in 1993. There had never been before a case in which a court granted a religious exemption, on a free exercise exemption, to a secular for-profit corporation. So this was really an unprecedented type of claims. And the claim was that based on the beliefs of the owner, the corporation is entitled to an exemption. And entitled to an exemption in a way that would have a significant effect on employees who would lose out on an important form of coverage. There were some details in the particulars, but it tended to break down that companies that were owned by Catholics tended to object to covering all forms of contraception. Companies like Hobby Lobby, whose owners were not Catholic but evangelical Protestants, objected only to covering emergency contraception and the IUD. Their reasoning was, although they don't object to contraception, they object to abortion, and they think that emergency contraception and the IUD can or might prevent a fertilized egg from implanting in the womb, and that they believed was an abortion. As an aside, even if you actually believe that preventing the implantation of a fertilized egg is an abortion, the scientific consensus now is that IUD and emergency contraception don't work that way, that they act to prevent fertilization. But in any event, here we were. And and these were, I think, the burden resulting from an exemption here are quite significant. Different forms of contraception have different price tags, but the IUD, for instance, which is, I think, widely considered the most effective form of contraception for women, has an upfront cost of over $1,000. And so even if you're saying, well, we cover 16 of 20 forms of contraception, if you're not covering the one that's, for a lot of people, most effective and also most expensive, then that's no small matter. So the cases worked their way through the courts in 2012 and 2013, and they got to the US Supreme Court and were argued in the spring of 2014. And in June of 2014, on the last day of the term, the Supreme Court issued a 5-4 decision. This was a hotly contested decision. It was written by Justice Alito, who's probably the biggest proponent of religious accommodations on the current Supreme Court. And the Supreme Court said that Hobby Lobby did not have to comply with the contraceptive coverage regulations. And there were a couple of important parts of this decision that are worth going over. The decision was initially reported in the media as being a very narrow decision, but I saw those news reports, and then I sat down at my desk later that day and started to read it, and I was like, this doesn't seem narrow at all. And in fact, it was actually arguably quite broad. So the Supreme Court and Hobby Lobby did a couple of things. The first thing they did, and this was perhaps the most significant thing in the long run, is they said the Religious Freedom Restoration Act is not tethered to the previous understanding of the Free Exercise Clause. So in other words, even though Congress in 1993 made it clear that all it wanted to do was restore the pre-1990 understanding of the First Amendment, the Supreme Court said, no, we don't believe that this act can be interpreted basically from scratch. And so, in other words, can be interpreted much more broadly than the Free Exercise Clause had ever been interpreted. One of the things that the Supreme Court did is said that even for-profit corporations could be covered, could invoke free exercise claims. So in the case of Hobby Lobby, although it was a closely held corporation, it has over 10,000 employees, and in fact, more than half of the country's workforce works for so-called closely held corporations. And the Supreme Court even left open the possibility that a publicly traded corporation could bring a free exercise claim, although it said it's probably unlikely. We'll see. So that was the first thing. The second thing the Supreme Court said is that we're going to be extremely deferential in determining whether there is a substantial burden on religious exercise. What we and what the government argued in Hobby Lobby was, look, this is too attenuated a burden. No one is forcing the owners or these companies even to use contraception or even to hand out contraception. All they're doing is saying, it needs to be covered in this insurance policy you provide that covers 1,000 different things, so that a woman can choose on her own whether or not to use contraception. And so, under normal principles of law in a lot of other contexts, an independent decision like that usually kind of breaks the causal chain. But what the Supreme Court said is we are not going to doubt. If someone walks into court and says, I have a religious objection, even to making this available to someone else to use at their own discretion, that's good enough for us. And so that was deemed a substantial burden, even though the ultimate decision to use contraception was many, many steps removed from the company or the company's owners. Then the Supreme Court, after saying that there was a substantial burden, looked at the question of strict scrutiny. They punted on the question of whether providing contraception coverage was a compelling governmental interest. But the court said there's another way for the government to do this without requiring it to be included in Hobby Lobby's plan. And the court was not entirely clear here, but the court said, one, it's possible that the government could set up a program on its own to provide contraception coverage. And two, the court pointed to an accommodation that had been offered to nonprofit organizations. So let me take a bit of a detour now and talk about that and then how that relates to what happened in Hobby Lobby. So for nonprofit organizations, entities like the University of Notre Dame or Catholic Charities or Georgetown University, those entities don't have to include contraceptive coverage in their health plans. All they have to do is either sign a form or write a letter to the government saying we object. And then the government arranges with those entities' insurance providers to provide the contraception coverage to their employees at no cost to the employees and at no cost to the nonprofit organization. And this actually ends up being an okay deal even for insurance companies because contraception is almost always cheaper than pregnancy. And so that accommodation was made available to nonprofit organizations. What the Supreme Court said in Hobby Lobby is, well, look, you have this accommodation for nonprofit organizations. There's no reason why you can't also make it available to for-profit corporations, and so therefore there's obviously a less restrictive alternative. And then as for the harm to women who would be sort of left in the lurch, in the meantime, the court said, well, there's not going to be any harm to affected women because if you apply this accommodation, they'll be taken care of. And so there end up being a couple of things in this decision. One is that for-profit corporations can bring free exercise claims. The second thing is that a substantial burden on religious exercise can be defined extraordinarily broadly. And the third thing is that if the government has made an accommodation available to one set of entities, it essentially has to make it available to another set of entities, even if the equities are different. And if the government could alleviate the harm to affected women, then we're going to pretend like the harm to affected women isn't actually happening. So that was Hobby Lobby. Justice Kennedy, as he sometimes does, wrote a concurring opinion. He was the fifth vote in Hobby Lobby, and he joined the majority opinion in full. But he also wrote a concurring opinion suggesting that the government did have a compelling interest in providing contraception coverage and suggesting that the nonprofit accommodation is sufficient to address any burdens on religious exercise. Because those cases are still going on. It turns out the nonprofit organizations, the people that have received that accommodation, are saying even that accommodation doesn't go far enough. And I'll be talking a little more about that in a moment. But at the end of the day, Hobby Lobby means that for-profit corporations can now bring free exercise claims. They can do so on very broad theories. And in some circumstances, the court will tolerate claims that impose burdens on other people, including employees, if the court can identify some other way for the government to perhaps provide for the service itself or arrange for someone else to provide for the service itself. And I think that last point is really quite significant because you can imagine all sorts of examples in which that could be the case. So I mentioned earlier in my talk a couple of cases, the company that didn't want to pay the minimum wage. Well, you could say, well, look, the government could always make up the salary difference itself, and so there's a less restrictive way. Or the employer who didn't want to withhold Social Security payments. The government could always kick in the money itself. And so when you're dealing with benefit and especially employment benefits, the argument that the government could always do it itself is potentially an extremely broad argument that could undermine all sorts of regulations of the private sector that are protecting employees or others. So that's Hobby Lobby. So Hobby Lobby has had the effect not only of making it harder for lots of women to get contraception coverage, but it has also now emboldened others who want to bring even more aggressive claims for religious exemptions. And we're seeing that in two areas already. One is the follow-on contraception litigation affecting nonprofit organizations, and the second involves non-discrimination laws, and in particular non-discrimination laws protecting LGBT people. So first of all, let's talk about the contraception 2.0, because if you thought Hobby Lobby resolved the contraception cases, you thought wrong. So as I mentioned, the premise of Hobby Lobby was, well, there's this accommodation you've already provided to nonprofit organizations, and that takes care of your interests, government. But many of those nonprofit organizations are challenging the accommodation. And although their argument has evolved over time, the basic argument is, by requiring us to either fill out a form or send you a letter objecting to the coverage, with the knowledge that you, the government, are going to then arrange with our insurance company to provide that coverage, you are still making us complicit in the sin of contraception use. That has been the argument. That is an extraordinary argument if you think about it for a moment, because pretty much anyone ever offered a religious accommodation could say the same thing. If I object to fighting in a war, under this theory, I could say not only do I refuse to go to war, but I refuse to even fill out a request for a conscientious objection, because at the end of the day, the government's going to choose someone to go in my place, and now I'm complicit in someone being drafted. Or if I were a judge who objected to the death penalty, I not only objected to hearing the case, but I refused to even recuse myself, because if I recuse myself, then the case is going to get reassigned to someone else and the death penalty might get imposed. So I have the right to simply have the case sit in my courtroom and not hear it. That's the type of argument that's being made by the nonprofit organizations, that we refuse even to request the accommodation, because once we do so, the government is going to arrange for our employees to get contraception for a third party at no cost to us. That argument has reached the courts of appeals. 7 of the 8 federal appeals courts have rejected that argument. 1 court of appeals has accepted it, but that case is almost certainly going to be in front of the Supreme Court in the next term. And if the nonprofit organizations win that argument, then all bets are off. Because at that point, literally anything can be a substantial burden on religious exercise, no matter how far-fetched and no matter what the consequence is to affected women in this case. So that's kind of realm 1 that we'll be seeing in the future. The next realm, and we've been seeing a lot of this in the news, relates to the intersection of marriage equality, LGBT rights, and religious exercise. This is highly related to marriage equality, although not necessarily always involving marriage. There's been several of these cases actually even predated the Supreme Court's decision, but we're starting to see a couple of different types of cases. The first type of case comes after the Supreme Court's decision, and that's the Kim Davis situation in Kentucky, where government officials refuse to provide government services based on religious objections. In Kim Davis's case, she objects to marriage between same-sex couples and has not only refused to issue the licenses themselves, but for quite some time sought to prevent her entire office from issuing those marriage licenses. The second type of case arises in employment. There are now new federal regulations that require government contractors to not discriminate on the basis of sexual orientation in hiring. And the Federal Equal Employment Opportunity Commission has also interpreted the Civil Rights Act to prohibit discrimination on the basis of either sexual orientation or gender identity, which means going forward, we may start to see people bringing free exercise challenges to non-discrimination suits in the context of employment. And then we have what's so far been the most common common conflict, which is in the realm of public accommodations. The bakers and the florists and the photographers and the farms who refuse to provide services to same-sex couples, be it I refuse to take photographs at a wedding, or provide flowers for a wedding, or a cake for a wedding, or use my property to host a wedding. There are now sort of 5 or 6 of these cases working their way through mostly state courts, in which people are arguing that they are entitled to exemptions, both free exercise and even free speech exemptions, from laws prohibiting non-discrimination in the context of public accommodations. So far, the discrimination laws have been upheld in most of these cases, but again, most of them are very early on, and it's quite likely that that too will find its way into the Supreme Court in the near future. I would say in all of these cases that the arguments in favor of applying anti-discrimination law, I would say, if anything, are even stronger than the arguments for the government in the contraception cases because of the issue of stigma, that when you are turned away from a restaurant or a florist or a bakery or a hotel or whatever, the harm is not just I need a place to stay tonight or I need a place to get a sandwich, but there's a deep stigmatic harm, and we of course saw that in the 1950s and the 1960s. For instance, the lunch counter sit-ins could not have been resolved simply by saying there's another sandwich shop down the street. There's a question of stigma, and so saying that the government could always provide the sandwich or the flowers, even if that is a viable argument in the contraception cases, isn't really a good argument in these discrimination cases. There may be ways to provide accommodations if it's done in a way that doesn't impose a stigma. So if there is, for instance, a particular employee who objects to issuing marriage licenses, I don't think most people, and I certainly wouldn't have a problem with that person, swapping duties with someone else. So if there's one person whose job is to process a database and the other person whose job is to hand out paperwork, and neither of them objects to switching, that seems to be a way that accommodations can be provided without interfering with the rights of people needing marriage licenses or even creating any stigma. But the notion that you would have the right under the Free Exercise Clause or under the Free Speech Clause or under the Religious Freedom Restoration Act to turn away someone from your store or your workplace or your government office would not only be the most aggressive yet invocation of religious accommodations, but would be really at odds with the country's civil rights tradition. And so as I wrap up my remarks, I sort of mentioned at the beginning that these are not your father's church-state cases, but I think we can look to the past to provide some instruction on how they should be resolved. In 1967, the Supreme Court ruled in a case called Loving versus Virginia that it was unconstitutional to ban interracial couples from getting married. And at the time, there were many people who supported bans on interracial marriage on religious grounds. In fact, the trial court in that case in Virginia upheld the ban, and he wrote in his opinion that if God intended for the races to mix, he wouldn't have placed them on separate continents. And so, that was in a judicial opinion. But the Supreme Court unanimously in 1967 said, we don't care whether it's tradition, whether it's religious objections, it is unconstitutional to prohibit interracial couples from getting married. And after that, you had similar types of religious conflicts. There was a owner of a restaurant called Piggy Park, which is a great name for a restaurant, but didn't have a great owner. And he said that he was not going to allow African Americans into his restaurant because he did not want to violate his religious beliefs that the races should not be mixing. He got sued under the Civil Rights Act. He objected on religious grounds. He said he should be entitled to a religious exemption. not only was his argument rejected unanimously by the US Supreme Court, but the Supreme Court basically said this argument is frivolous. The notion that you would be entitled to a religious exemption from an anti-discrimination law when you are a public business was essentially nonsense to the Supreme Court in 1968. And I think anyone, would agree that in 1968, and certainly in 2015, the notion that a government clerk should be able to deny service to an interracial couple, or that an employer should be able to refuse to hire an African American, or that a bakery should be able to refuse to bake a cake for an interracial wedding, would be laughed out of court. And yet, the same arguments now are being made in an effort to justify discrimination against LGBT people. And those on the religious right are often going at great pains to say, well, no, race is different, and discrimination on the basis of race is worse than discrimination on the basis of other categories. But, I think without having to go into which group has suffered worse history, certainly LGBT Americans have suffered from unconscionable discrimination for quite a long time. I think we as a country are increasingly recognize that they are entitled, LGBT Americans are entitled to the protection of the civil rights laws. And to be accepting arguments that would have been laughed out of court in the 1960s in the context of race, to accept them now in the context of sexual orientation or gender identity would really be to make a mockery of religious freedom. And that, I think, is actually the ultimate harm to this new kind of aggressive, more weaponized use of religious exercise claims, which is that broad consensus that existed in the early 1990s that accommodations in some cases can be reasonable and are actually an important part of a religiously diverse society and an important way to protect minority rights. That consensus is now falling by the wayside. That support for even reasonable religious accommodations is going to decline because of sort of the free exercise plaintiffs who cried wolf. And that in the long run, the misuse and the over-aggressive use of religious accommodations is going to be bad not only for civil rights and civil liberties, not only for minorities, secular minorities, but also for the cause of religious liberty itself. Thank you.